Hi, this is Dwight Lilly with the Dwight Lilly Show out of Pahrump, Nevada. And what we're going to be doing today, this is the very first video on this new channel I have here, is I'm going to be covering issues having to do with Nevada, Southern Nevada, Pahrump, Nye County in particular, and I'm recording them on YouTube along with Facebook Live, except I'm doing separate videos for both. To keep the people informed here in the greater Pahrump area, the greater Nye County area, as to what actually is going on from my perspective. And secondly, to prohibit whoever has been protesting to Facebook to take my videos down, to prohibit that from happening and any content being lost in the future. So today I want to cover a meeting that was held in Pahrump, Nevada, having to do with the state engineer's order number 1293 that was heard originally at the last Nye County Commissioner meeting a week ago on Tuesday, which would have put that right after the New Year's. Right after New Year's. What happened at that meeting was it was determined that the issue actually had to do with the town of Pahrump and not Nye County, as to whether or not the government here was going to pay for legal fees to challenge state engineer on his order number 1293. And so today at 10 o'clock this morning, the Nye County Commissioners, who are also the quasi Town of Pahrump board members, opened up the meeting, and boy, my nose itches today. Opened up the meeting with item number 1, which was a item. I will read you what the action item was. It was discussion deliberation to consider hiring an attorney to take legal action in opposition to order number 1293 that was issued by the Office of the State Engineer of the State of Nevada on December the 19th, 2017, which would have been a couple weeks ago. Now, what this order had to do with was, because of the severe over-appropriation of water rights in Basin 162, this is Water Basin, Hydraulic Basin 162, which is the water basin underneath the town of Pahrump, the state engineer decided to stop domestic wells from being drilled. And the approach he took to stop it was to make it cost prohibitive for somebody that had a lot that was over an acre size, because you have to have at least an acre or larger lot in order to drill a domestic well right now. In the past, they did have some cases where they had half-acre lots that have wells on them, but that hasn't been the case in a long time. And what happened was the state engineer issued this order. And it operates two ways. Number one, if you happen to have a lot that you wanted to build on that had had water appropriated to the lot, be it like in a subdivision or in some other fashion, whether a standalone lot or not, then you could drill a domestic well. If, however, there was no water on the lot dedicated to it, then you would have to purchase 2 acre-feet of water, which, because of the order, has now inflated from about $3,500 an acre-foot to over $10,000 an acre-foot. So you would buy 2 acre-feet of water, which would cost you $20,000 plus transfer fees, turn those 2 acre-feet of water over to the State of Nevada Division of Water Resources, and then you would be allowed to drill a domestic well. Now, this isn't covered in the Nevada revised statute at all. What it says in Nevada statutes is those that have an acre or more size piece of property have a right to a domestic well in the state of Nevada that can pump 2 acre-feet of water in a year's time. So this is a special order that Jason King, the state engineer, has issued, and he bases this on in a legislative action in 2007 which gave domestic wells a priority date. There's never been a priority date applied to domestic wells in the past, and this, in a sense, is, I think, the first time it's ever been acted upon. Priority dates have always had to do with water rights, and a domestic well is not a water right. Anyway, I'm not going to go into water law right now with you. I may cover that in another episode here on YouTube. But suffice to say is that this upset a lot of people. A lot of people. And so how did it come about? Well, it's been driven by the Nye County Commissioners and the Nye County Water District Governing Board to take action that would decrease the amount of water being used in Nye County by domestic wells in Pahrump, so that that water can be used for high-density development. That's the bottom line right there. Now, we've had a Nye County Water District Governing Board since 2007. Didn't become operational for a couple of years until funding was secured. But originally the intent of that, the mission statement, is to protect and preserve the water resources in Nye County. However, what's happened, it's been used as a driving force of special interest, the special interest being the development community and the utility companies, to force domestic wells out of existence, in a sense, or to stop them from being drilled, and that water be made available for building of homes, and mainly the south end of Pahrump. Now you say, well, how can this come about? Well, in Nevada, and in particular in Nye County, which in a 2010 article was labeled the most corrupt county in the United States of America, lots of things happen that are not always in the best interest of the majority of the people. There are 11,250, basically, domestic wells in the Pahrump underneath Basin 162. And, each one of them having a right to 2 acre-feet of water. So the entire basin only recharges from the Spring Mountains. In other words, yearly, how much water flows into the basin from melting snow and water that's drained through the mountains? 20,000 acre-feet. So every domestic well already drilled already takes up all of the water of the recharge. And this left nothing for other development. Now, the other development is being ran by people that used to have large farms that they split them up into developments so that they could sell houses on them. And some other developers came into the area and bought property and decided to build large subdivisions, some of them in excess of thousands of homes. But needless to say, there's not enough water in Basin 162 to satisfy the legal right of all the well owners, along with providing water for the development community that don't have wells on smaller lots. Well, that doesn't stop these pirates. They simply have utilized the water district, the county, some of the county commissioners, in particular, the commissioners that have been involved in the water district, whether as liaisons or not. They kind of have tag teamed and formed a water plan that led down this crooked path to where we are right now. I don't want to go off into history here. This being my first YouTube channel, I'm not going to spend an hour here talking about this stuff. But let me get back to the meeting. So anyway, the first item was to whether or not to hire an attorney. And after lots of testimony, people from real estate, I talked on it because I'm a member of the board of directors for the Private Well Owners Co-op, and other people that had bought lots. One guy in particular had bought a lot 6 days ago. In other words, after the state engineer's order, and now he's like, well, wait a minute, I got to buy 2 acre-feet of water? Well, I would think that his sale, in that particular case, he could have it rescinded by simply calling up the real estate agent and whoever's handled the closing of his sale, and say, listen, there's fraud that's taken place here. I wasn't disclosed to me that if I bought this lot, that I was not going to be able to drill a well without buying 2 acre-feet of water. A particularly emotional scene took place when a young married woman with a baby, must have been about a year-old baby that was in a harness on her chest, gets up to speak before the commissioners, and she says, well, my husband and I recently bought our dream 5-acre plot of land. My husband working his tail off to pay for this, to build our home. We don't have $20,000 plus to go buy 2 acre-feet of water. And she was crying on the stand. It was a very emotional situation. There's lots of emotions going on this issue. Anyway, after all the discussion, the commissioners voted 3-2, I believe it was, to not fund out of the town of Pahrump a lawsuit, legal action, I should say, not necessarily a lawsuit, but legal action, which if a state engineer issues an order like this, there's a process that you can appeal it, but it takes legal action. And an attorney was there that had been talking to some real estate agents and so forth, and I believe talking to some of the commissioners, and it sounded like was going to be the attorney representing the county, but he didn't get a chance to because the commissioners, after hearing testimony and everything, decided, well, we're not going to fund this lawsuit. Which takes us to the second item, and that was item number 4, discussion and deliberation to direct the Water District Governing Board to identify, quantify, and investigate the relinquishment of water rights within subdivisions without infrastructure. 2, to investigate the feasibility of community wells. And 3, to investigate the feasibility to give an option in the town of Pahrump to choose a conservation well as opposed to purchasing 2 acre-feet of water rights. Okay, now, there is no conservation wells in Pahrump. I don't believe there's any conservation wells in the state of Nevada. I haven't heard this brought up, but it's a proposal that to investigate whether or not it would be wise to offer people in Pahrump who have a lot and don't have water rights allocated to it, that they can opt for a conservation well that only pumps a 1/2 acre-foot of water a year and not have to go buy those water rights. The other thing, the community well, again, we don't have any of these community wells, but how it was defined, a community well would be like 14 lots with a maximum, I believe, of 25 people, all getting water off one well. Now, if it went to, as I understood it, if it went to 15 lots, then it would be called a quasi-municipal. In a sense, it would be a utility, and they'd have to go through the whole process of forming a utility. But you could go up to 14 lots on a community well. Now, as the testimony I heard and understood, that there are some community wells in the state of Nevada, but there's none in Nevada. The first item having to do with the identifying and quantifying, investigating the relinquishment of water rights within subdivisions. Now, this was a real murky area because what's happened years ago, even though we had a planning department that's been in effect since 1998, and even though the town was becoming sort of sophisticated about the 2000, in a sense, people moving in, that there's all sorts of lots in the Pahrump area that had just sort of, the paperwork's been lost on them as far as whether water had been allocated to the lots. Just real murky. The state engineer really doesn't have a handle on how many wells are in this area. And it's kind of like coming from the old Wild West to trying to come into the 21st century. Except the county and the water district have known about this situation for years, and it's never been really openly discussed in the community because it'd be put a big black mark on them. What's wrong with you guys? What's wrong with this county? Well, the more that you're not transparent, eventually things come out. And even though the current commissioners never had anything to do with some of these subdivisions and murkiness way back when, they still swore an oath to uphold the Constitution of the United States, the Constitution of the state of Nevada, and the laws. And the law says that you cannot have a well put on property without the state engineer okaying it. You have to get a permit to drill a well, and the lot has to be approved to have a well on it by the state engineer. In the case of the development, the state engineer signs off if water rights have been applied to that lot in a subdivision. In other words, you want to have a subdivision of 20 homes, let's say 40 homes. The developer has to relinquish 3 acre-feet of water for every 1 acre-foot in a subdivision for building houses, but in the case of domestic wells, they just had to give up 2 acre-feet, which should be for most of these developments, and apply that to that lot, and in that way the domestic well could be drilled and have water to it. Well, so like I said, some of these lots didn't have. I'll give you an example. Calvada 14, one of the developments, when it was all the paperwork was going through, that this company called what was it called? Oh boy. Anyway, a company, a large landholder, decided they wanted to put a development there. The state engineer denied domestic wells on the development, and this was back in 2001, I believe. Preferred Properties, that's the name of the company, Preferred Property. And the reason given in the letter of denial was that the valley had already been over-appropriated. There wasn't enough water coming in on recharge, and therefore he does not allow any more domestic wells and subdivisions. And that was a letter he told them, issued to them on that development, Calvada 14. So Preferred Properties had a utility company they owned called Central Nevada Utility. And so the utility company they owned signed off on the development that they would supply water and sewer to the lots in a development, except they had no infrastructure, no sewer lines, no water lines. In fact, the closest utility sewer plant or water plant, treatment plant they had was miles away. But this is Pahrump, so they got Nye County, the most corrupt county in the United States, so that, went ahead like that. But what's really murky here is that since no domestic wells were allowed on that subdivision, there's now like 93 domestic wells and people living on their properties there. Properties have been sold. Well, how did this happen when the state engineer said there couldn't be any domestic wells? Going a little murkier, there's only 73 approximately of these lots that have well logs, and another about 20 lots that apparently wells were drilled without any authorization from anybody. They just drilled the wells and the people are living there. So this applies to this item number 1 item 4 and subsection 1. Is we need to find out about this. They're doing an inventory, and the records are all goofed up and everything, and because it's from the old Wild West, just come in, sell some desert, piece of desert, come and get your piece of Palm Springs of Nevada, and it's just a mess. But anyway, after all sorts of testimony, this item came up for a vote and was tied because Lorinda Wickman, a commissioner from the 1st District, left the meeting. She was up in Tonopah, allegedly she had to go somewhere else right when the vote was coming up. And the same Lorinda Wickman, whose husband happens to be the manager of the Nye County Water District, which is a whole other story. I'm going to go through that whole sordid tale here in another YouTube. But this item tied 2-2 votes, and in a tied at 2-2 votes, I was always led to believe, and it's always been so that I've seen, is that the item dies because it did not have a 3 majority vote. Except to add a little drama to the scene, the Nye County District Attorney Angela Bello and the town manager Tim Sutton, who used to work for Angela Bello in the DA's office, they're huddled around laptops looking at laws, and after the last public comment period, the Nye County Commission Chairman, John Connick, close the meeting. And Angela then's like, you need to reopen the meeting. You need to reopen the meeting. We're still looking at the technicalities here. And I guess in trying to find a loophole to either carry this item over to another meeting or something. I'm not really sure why she was interfering other than this, typical Nye County politics. So there you have it. So both of those items failed. So where are we at? Well, Jason King had come on like a speakerphone during the first item that I mentioned, item number 3, discussing whether to hire an attorney. And he basically laid it out there. He said, we've been wanting to stop domestic wells in Pahrump for a long time. The reason we haven't taken action is because of a lawsuit that John Basta had challenging the engineer's authority. But that lawsuit died, was thrown out by the state Supreme Court, and now he took action. He was speaking on a speakerphone surrounded by Levi Kreider, one of his right-hand people, just people from the Nevada Division of Water Resources, and he's like, no, I don't want any more domestic wells. So that's where we're at. So at this point, January the 10th, 2018, if you have a lot that hasn't had water dedicated to it, then you have to go buy 2 acre-feet of water in order to drill a well and spend an extra $20,000. Now, there's people all over the place, evidently, contacting real estate companies here, saying what's going on, because they, in the last year, over 200, something, I think 228 was the number given or something, of how many lots were sold in Pahrump. Now, how many of them actually have water dedicated to them? Who knows? Because, again, it's all very murky. We don't know which of these lots do, and that has to be determined. But if they don't, then the people bought a lot that are going to have to spend an extra $20-some thousand before they can drill a domestic well, and they're going to be steaming. In fact, the whole area is steaming. There was going to be a meeting called tonight, and I was invited to it, sort of, but I maybe the meeting didn't get called because I never did get a text message telling me to go to the meeting, of realtors and people like, what are we going to do? Maybe we should hire an attorney since the county won't, or the town of Pahrump won't. So, but obviously there's going to be some action taken to try to stop this order from going forward, whether or not it's some type of a legal action where you get a stay of execution, in a sense, before it can go on, and it sort of stops the engineer's action until a court can hear about it or it can be worked out. But I don't know if that's going to be an effective way to go, because the governor's office, legislature, they're all intent on solving the water situation in Nevada. And the state engineer is who they have as their man taking care of business. And so if the state engineer has told them that I want to stop domestic wells in Pahrump because it's over-appropriated and the water level keeps dropping and dropping and it's turning into a critical situation, then I doubt the legislature is going to step in and help Pahrump. Maybe. I doubt the courts are going to step in and overthrow legal action by the state engineer, because he has the authority, according to him, to do this. Now, I disagree with it having to do with private wells, but that doesn't make any difference. What I disagree with, and those of you that know this situation well, because in the state of Nevada, just because you've had previous Supreme Court rulings stating that, yes, you do have a right to your well and the state engineer can't stop you, it's Nevada. Remember, it's Nevada. Things happen here differently, and are you going to stand out on your property and say you can't come in and do anything to my well when the National Guard shows up or whatever? I'm getting a little bit off there. But anyway, that's where we're at right now on this. And I have a Facebook Live on my Dwight Lilly. If you go to Dwight Lilly on Facebook and you see a radio, an old-fashioned radio, because there's 2 Dwight Lilly channels there, then click on that and you can hear a much more precise and detailed version of what happened today, but I don't want to spend that many minutes. This is about 25 minutes, and that was about 48 minutes. So this is about double the time. So anyway, I'm going to get off here, and hopefully I can get this uploaded onto YouTube, and if I can, it'll be my very first one that I've successfully uploaded. So this is Dwight Lilly with the Dwight Lilly Show, the guy that's going to be the next Nye County Commissioner from District 5, signing off.